often people view certain formal legal arrangements as something that they can easily change, and in most instances, unilaterally. And this is a concern because in most instances, when you have entered into a formal legal arrangement, it's not something that you can simply, and in most instances, unilaterally change as you wish, because now you've decided to change your mind. I'm going to make an example for you to clarify on this. For example, many people who are married in community or property, in most instances, you'd find that the spouses are obviously not equal in terms of wealth. The other one probably came into this marriage with nothing, and the other probably came in with almost everything that is in this marriage. Now, even though they know they are married in community or property, there's often this one who is much more wealthier, who thinks that they can simply dictate to what's going to happen to their assets going forward because they came in with a lot, altering the arrangement that they're already in, which is a marriage in community of property. Is this a possibility? We're going to talk about it in 1 second. But before we do so, I want to introduce myself to the people that are new here. My name is Yolanda Nyangeza. I'm an attorney by profession, working at a law firm called Nyangeza Attorneys as a director. So if you're here for the first time, thank you for coming. And make sure that if this educates you, you share it with other people, because we also want them to get the same amount of education that you have received. Let's talk about today's topic. So let's talk about the first type of legal arrangement that people think that they can simply change or alter with some form of agreement or whatever the case is, and they think that they can do so very easily and unilaterally. Let's talk about the first one that we just discussed, which is a marriage in community of property. So there are people who are married in community of property, especially those that are wealthy in the marriage, right, who seem to have this idea that because I came in here in this marriage in community of property, I can simply, dictate in my will that, okay, my properties are going to be inherited by this person, by that person. And the law is going to ensure that all of that happens. But for some reason, they don't consider or think about the fact that they are married in community of property. So how is it that you can simply just dictate, to what's going to happen to all of your properties? Because now your properties are shared with your spouse. Yes, they came with nothing, but what does the law say? The law says that when you enter into a marriage in community of property, we bind everything and we share everything equally. This is equally the case when they want to sell something. They seem to have this idea that they can simply get rid of a certain property because as much as they're married in community of property, they had acquired that property, forgetting that as soon as they entered into a marriage in community of property, it's not about them anymore. Everything that they owned now belongs into this joint estate, meaning that if they want to do away with that property, they then have to get the consent of the other party. And here's the thing. To those that have actually stipulated in their wills that, no, my properties are going to go to so-and-so, or no, I think my properties are going to so-and-so, you are in for a big surprise. In fact, so-and-so is in for a big surprise if they are already aware that they're going to be getting certain properties. Why? Because you cannot just leave properties that are also half owned by another individual. In fact, if you have said that a property situated at this place must be given to so-and-so, you must just know that you're speaking to half of that property because the other half is owned by the other spouse. So do you see? You cannot just unilaterally make these changes. You cannot just decide to now get out of the legal arrangement that you're already in. If you want to get out, it's only one solution, and we all know it. So now the second type of arrangement that people think that they can just chop and change, utilizing maybe some form of additional agreement or a document, is the arrangement of a trust. Now, if you recall, a lot of people opt to set up a trust, one, to have properties moved there so that they are safe and secure, or else for estate planning purposes, right? And that particular trust or arrangement, has terms and conditions that govern it, in a sense that how it operates is governed by terms and conditions we call a trust deed. Now, for some reason, people think then that because they were the ones who set up this trust for the benefit of their family or whoever, they can simply chop and change the terms by having an additional will. And this is something that a lot of people are meant to or are still going to be surprised by, because a will is not going to alter that arrangement, which is a trust. That legal arrangement exists and is guided by what? By certain legislation and also by a trust deed. Now, if you want to make changes, you're not going to draft a document that is unrelated to it. Remember, a will speaks to your affairs. You're talking about things you own. You cannot now dictate to what must happen in a trust which you are not an owner of. Yes, you did set it up, but you're not an owner of. So you're not going to dictate to how it should now continue to operate all of a sudden because you have drafted this thing in your will. In fact, it's very useless. A trust is dealt with in a trust. If you need to make changes, you speak to your legal practitioner about those changes. Also, it's important when you're drafting deeds that you think about a lot of things, the future, not only just the present. The reason why people want to make alterations in their wills is because that particular deed that they have is not sufficient to cover certain aspects. And they think, unfortunately, that that will is going to come in handy and sort out those things, to cover up those things that were not covered in that trust deed. This is why a trust deed has to be drafted extensively and thinking about the future. So do not think for 1 second that you can impose changes to a trust on your will, because 1, you are not the owner in a trust, you are just a beneficiary. And 2, a will speaks about your assets, things that you own, and you don't own a trust. Let's talk about the third legal arrangement that people think can just be altered as and when you like. What type of decision or legal arrangement are we talking about now? We're talking about this arrangement where people buy properties in other people's names and think and seem to have this idea that this type of legal arrangement is not something big because there's an understanding between them and the person who owns the property. So what tends to happen is that certain people, whether out of malice or for good cause, would have this idea of not purchasing any movable property out of their, or rather under their name, but under another person's name, be it a sibling, be it their parent, whatever the case is. And they seem to think that whatever arrangement, let's say in terms of discussion they have with that person whom now is the owner of the property that they have decided to buy, is going to override whatever ownership that's currently there. Meaning that, let's say if the sister or the sibling now passes away, it means that that property is theirs. Is that the case? But it's not, because that arrangement that they have does not supersede the legal arrangement that is intact, that is in place, which is that that person who is the registered owner of the property fully owns the property. And if they want to do away with it or transfer it to them in the future, they will have to agree to that. We've seen this with parents. They've done it a lot. They've moved or bought properties under children's names. When those kids are of age, they decide, I want you out of my house. Parents often want to fight this. But I was doing this for the interest of this family, for the interest of this child. What does the law say? This is not a legal arrangement that you can just chop and change. It stands and it is intact, and the owner dictates to what happened to that property. It's the same with people who have used siblings and other parents. Next thing, that person passes away and they want to use the legal arrangement that was in place. It's not that people don't know that there was a legal arrangement, right? That was discussed about, the situation of this ownership and why it was moved or registered under another person's name. But how is it helpful? When it comes to the law, it's not really helpful. Because why? That property belongs to an individual and that individual rightly owns it. Guys, be careful. Legal arrangements require for you to ensure that you know exactly what the consequences are. You cannot just chop and change as you wish, because they are what? They're legal arrangements deep rooted in law, and they need certain processes to alter them. So be careful when you're going to make any type of decision that we've talked about on your part. So I hope this is going to be helpful to you. Listen, if it was helpful, make sure that you also pass it on to somebody else so that they can also get the amount of education that you have received. We shall see you next time.